So good afternoon, everyone. My name is Patricia Taylor. I am a litigation and regulatory associate with DLA Piper and the Vice President of the Scottish Young Lawyers Association. Thank you so much for joining us today for the next in our Precognition to Proof series, where today we will be lending our focus to the options hearing. And as we progress through the session, please do post your questions into the chat box. We want this to be as collaborative as possible. And please note there's no silly questions. I'm sure if you're sat in the audience with a particular question for David, who's hosting the session, someone else in the audience will have that question too. Or alternatively, there'll be an option at the end of the presentation for you to pose questions to David as well. So as I've alluded to, today's session will be delivered by David Blair, who is an advocate at the Scottish Bar and is represented by Axiom. So David called to the bar in 2021 as a faculty scholar, and during his period of dibbling, David gained experience in a variety of public law matters, including immigration, housing law, prison law, and human rights cases. And he was also involved in a number of commercial disputes and clinical negligence actions. And as a solicitor, David worked in the healthcare, public and regulatory team at Anderson Strathearn. David worked on a wide variety of public law matters and has experience of judicial review and statutory appeals to the Court of Session. And he also maintained a practice of medical negligence and personal injury work. So as you can tell by that synopsis, we're in very good hands today. So without further ado, over to you, David.
Thanks, Patricia, and thank you for extending the invitation from the Scottish Young Lawyers Association to speak at this session. I'm hoping that it's less embarrassing than my last involvement with SILA, which was as an attendee on behalf of faculty at the SILA ball. As a lawyer who's still just gripping on with his fingernails to his 20s, I would have considered myself a young lawyer, and I suspect within the confines of the Advocates Library, I still count as a young lawyer. Having turned up at that ball, there was a real sense of sort of, how do you do, fellow kids? A real sense of, certainly by the time the disco started, I felt very much like one of the teachers supervising the school dance. So thank you very much for asking me to attend and to talk about a subject matter which I'm sure is just as young and cool and hip as the SILA ball, options hearings. So I think it's useful to have a discussion today about the options hearing, what the options hearing is for, and why the options hearing is important, and what a litigator should do in preparation for the options hearing and during the options hearing. For many cases, the options hearing will be the first time that a case actually calls in court. That's not true for all cases. In some cases, we'll have motions for interim orders, etc., or specifications of documents. And indeed, some cases in some jurisdictions won't even have an options hearing call at all anymore if it can be dealt with administratively. But certainly, as envisaged by the ordinary cause rules, the options hearing is really the point at which the court becomes involved in the case and starts to consider case management and where the case should be going. And really, I think a helpful way to think about the options hearing is it marks the boundary between, on the first hand, the stage at which you're trying to work out what your case is about, and that's done by setting out in the pleadings what you say the case is about, what orders you're seeking to recover, and what pleadings you need in order to offer to prove a relevant case. And then the second stage of a litigation, which is about working out how to prove your case or how to be successful and obtain the orders that you want. And the options hearing really is the bridge between those two stages. And it's really a case for the court in association with the parties to discuss further procedure and work out how to get the case to a conclusion. In terms of what I want to talk about today, in terms of a structure, I think what I intend to do firstly is to talk a little bit about what you should be thinking about prior to the options hearing, and provide a bit of a checklist for things to double check, things to ensure that you've done, things to think about. Then to have a bit of a discussion about what the fundamental purpose of the options hearing is, and what the discussion about further procedure is likely to look like, and what options are likely to be considered by the court. And then lastly, to provide a bit of sort of top tips, as it were, for things to bear in mind as you prepare for the hearing itself and consider what submissions you'll need to make at the options hearing. As Patricia says, if there's any questions, feel free to fire them in, and I'll either answer them as we go, or we can have a discussion at the end. If we turn to the first issue, then what do we need to consider before the options hearing itself? Your preparation for the options hearing can't begin the night before the hearing, or dreaded to think on the morning of the hearing. I appreciate there are circumstances in which solicitors will be passed files on the morning of the hearing and told to turn up at the options hearing, but certainly that's not ideal, and certainly somebody involved in the case should have put in the thought and preparation prior to the options hearing. And there's a few issues that I think it's helpful to just think about. Firstly, make sure that you are aware of when the options hearing is. That should have been fixed at the time that defences have gone in, and the court should have notified you of when the options hearing is. That's important for a number of reasons. Firstly, an options hearing is a peremptory diet in terms of the rules, and failure to attend the options hearing could result in a decree by default. That's perhaps unlikely to happen. You would hope that when the notification comes in, you should be clear to diary that properly, so that you know when to attend at the options hearing. But there are other deadlines which flow from the options hearing itself, and so it's important to have it diarised when the hearing is, so that you can work backwards from that date with regards to various other deadlines which will arise. Those deadlines, turning to them, the first thing that I think is important to bear in mind is you need to complete your adjustments prior to the options hearing. So your adjustment period in terms of Ordinary Clause Rule 9.81 allows for adjustment to continue on the open record up to 14 days prior to the options hearing. So in essence, your adjustment period finishes 2 weeks prior to the options hearing. Now, frequently, there are cases in which agents will continue to informally adjust after that 14-day deadline, and that can often be agreed as a matter of agreement between parties, that doesn't cause an issue if there are points arising that require further adjustment. But I think it's important to bear in mind when the formal deadline of 14 days is, because any adjustments which are intimated after that date, even if there's an agreement between parties that there's no issue with that, they should really be subject to a motion at the options hearing for those adjustments to be received late. In terms of finalising your adjustments, I don't want to go over ground which has been discussed perhaps in earlier sessions about drafting pleadings, drafting initial writs and defences, but it's important that by the time you reach the point where your record is closing, you have a clear case theory and a clear idea of what your case is about. And this is probably old stuff either from the diploma or from other sessions in this series, but your closed record is really the document which should tell the story and the full story that you intend to tell the court. It should set out everything, subject to not being overly verbose and not pleading evidence, but it should set out everything that you intend to offer to prove to the court, and all the averments that would be necessary to provide evidence in support of at proof. And that's important because any changes made to the pleadings after the deadline for, after the record is closed, would require to be subject to amendment rather than adjustment. And as I'm sure we're all aware, amendment is at the discretion of the court. You don't have an entitlement to amend, and so you always run the risk, if trying to introduce further averments after the record is closed, that the court simply either says, no, you're not getting those averments in, or perhaps more realistically, it'll cost you, because there'll be an award of expenses against you for incurring the further cost of the amendment procedure. So it's important to make sure that you have a clear idea of what you're saying, to tell a clear story in your record, to contain all the averments that are required in order to make your case out at proof. And it's also important to make sure that your record is intelligible, comprehensible, and easy to navigate, bearing in mind that fundamentally this is an advocacy document, which the court will seek to use as a way of understanding what the case is about. And there's some guidance, I think, that's quite helpful from the Sheriff Appeal Court on that issue from relatively recently in the case of Donnelly against South Lanarkshire Council. The reference for anybody who wants it is 2021 SAC Civ 30. And at paragraph 27, the court said, parties are each responsible for their own pleadings, the purpose of which is to set out the material facts and the propositions of law on which reliance is placed in support of a claim or defence. The court should be able to identify with precision the matters upon which parties agree and those upon which they differ, and by doing so, identify the case upon which it is asked to adjudicate. A clear understanding of the rules of pleadings equips pleaders to better serve those instructing them and assists the court in performing its function. Lucid, well-ordered, and concise written pleadings assist the court in its task. Conversely, unintelligible verbose pleadings, averments of evidence, and legal submissions in the form of averments significantly hinder the court. In this regard, it is the pursuer who sets the tone, with the defender required to answer the pursuer's averments. It is the pursuer who is responsible for the presentation and form of the record. So that's perhaps some guidance on what the court expects to see in terms of the pleadings by the time the record closes at the options hearing. In terms of other matters to bear in mind on your checklist, the next thing I think it's important to remember is the Rule 22 note, formally referred to as the note on basis of preliminary pleas. And certainly when I was training, everybody was warned that one may face the wrath of certain old-fashioned sheriffs for referring to it as a Rule 22 note rather than a note on the basis of preliminary pleas. I have seen in the most recent edition of McPhail's Sheriff Court practice, even they now refer to it as the Rule 22 note. So hopefully there won't be any knuckles wrapped for using that helpful shorthand. And in terms of deadlines, in terms of Ordinary Cause Rule 22.1.1, any Rule 22 note must be lodged at least 3 days prior to the options hearing. The purpose of the Rule 22 note is to give some fair notice and some specification as to the arguments that one would seek to make in support of any preliminary pleas in your pleadings. So if you intend to take a time bar point, if you tend to take a relevancy point, a specification point, a jurisdiction point, the Rule 22 note ought to set out in fairly concise terms the arguments and the points which you would seek to make either at a debate or at the close of a proof before answer. In that sense, for those of you who do any court of session work, it serves a similar purpose to the note of argument that you see in a lot of court of session litigation, although I think in practice your Rule 22 notes tend to be a bit more concise and less detailed. You don't need to set out chapter and verse on what your argument is. You really need to set out the propositions of law that you would seek to rely upon and say why they apply to your case in pretty brief terms. And a good Rule 22 note can often only be a page or two. Bear in mind, one other point on the Rule 22 note, I'm just reminding myself there, the Rule 22 note is in support of your preliminary pleas. you'll need a Rule 22 note if it's your intention to seek a debate, but also if your argument is that there are preliminary pleas that ought to be sustained at the end of a proof before answer, then a Rule 22 note will require to be lodged even if you are seeking for the case to be remitted to a hearing on evidence by way of a proof before answer. The last thing to bear in mind prior to the options hearing, and this is one for those acting for the pursuer, is to make sure that you lodge the record. So your adjustments will have closed 14 days prior to the options hearing. And then in terms of ordinary cause, Rule 9.11.2, a certified copy of the record is to be lodged no later than 2 days prior to the options hearing with the court. Bear in mind that must be a certified copy. You don't want to get caught out and have the clerks bounce a record for not being certified and to then have the embarrassment of seeking to have it received late. In terms of what your closed record should look like, if a competent open record has been maintained during the adjustment period, with all the changes being shown in track changes, then there shouldn't be much to do other than to change the heading of the record to closed record and to accept the various track changes so that you have a clean, clear document which tells the stories. And we've already spoken about the requirements in terms of what your pleadings ought to look like by that point in the case. So that's what you've got to do before the options hearing. Now, what is the point of the options hearing and what are we doing at the options hearing? Well, it's really set out in the rules. In terms of ordinary cause rule 9.12.1, at the options hearing, the sheriff shall seek to secure the expeditious progress of the cause by ascertaining from the parties the matters in dispute and information about any other matter referred to in paragraph 3. And paragraph 3 really goes on to set out the various types of procedure that the case might be appointed to at this point. Now, fundamentally then, what the options hearing is about is further procedure. You've reached a point in which the record has closed, and so far the case has followed the same procedural structure as every case will follow under the ordinary cause rules. And it's when you reach the options hearing that the court and the parties are faced with a choice. And that choice is, what are we going to do next? And there are, as I can ascertain, a number of possible ways forward at an options hearing procedurally. And we'll talk about each of these in a bit more detail in a moment, but just to set them out for you. The first is that the case may be appointed to a proof or an evidential hearing. The second is we may have a proof before answer. The case may be appointed to a debate. We may fix a preliminary proof, which is simply a proof which is focused on a specific or a number of specific issues rather than the whole case. You can seek to continue the options hearing under certain circumstances, and we'll discuss what they are and the limits on that. Or you may seek to have the case appointed to the additional procedure in terms of Chapter 11 of the Ordinary Cause Rules. So how do you know what type of procedure that you should be seeking at the options hearing? Well, if we go through them and discuss the nature of the different types of procedure, then that should assist in your case analysis and working out what it is that you want to happen to a case. So if we look at proof first, I'm sure much of this is familiar to you. A proof focuses on disputes of fact. There will be matters which are disputed in the pleadings with regards to what did or did not happen. And the object of a proof is to allow evidence to be heard in support of each party's averments. And at the end of the proof, the sheriff will consider what has and has not been proved and whether the decree sought by the pursuer or decree sought by a counterclaimer, if there's a counterclaim, whether that ought to be granted. An important aspect of the fixing of a proof is that the preliminary pleas of the parties will be repelled when the record is closed. If you are looking to fix a proof, or if you consider it likely that the other side may be looking to fix a proof, and therefore the court might be considering fixing a proof, there are various matters that I think it's helpful to go into an options hearing having a clear idea of, and to be able to advise the court in terms of your views. The first of those is the likely duration of a proof. Now, this might depend to some extent on the sheriffdom in which you are appearing. Some sheriffdoms will still allow multi-day proofs to be fixed. So you might be able to say, well, this is a case that's going to take 4 days. So can you fix a 4-day diet for proof? There are other sheriffdoms, and I think this is increasingly the case because of logistics issues and capacity issues, that will essentially fix a single diet, even if the proof is never going to finish in a single day. And when it does get continued, simply another date will be fixed later, and another date and another date. But I think it's helpful at the outset to be able to advise the court, having regard to the scope of the issues in dispute, how long proof is likely to be. And the only thing I would say in terms of that is be realistic about your timings. A sheriff will not thank you for being overly optimistic that you can get a case done in 2 days if it then turns out to take 2 weeks. Better to fess up early and say this is a complicated, difficult issue, and to budget for more time rather than less. Think about availability issues. And when I say availability, I'm really thinking about witnesses, I'm thinking about experts, and I'm thinking about if counsel are instructed, and indeed your own availability as a solicitor. It would be frustrating for the court if it fixes dates that you have said are fine, and then it turns out that you're on holiday, one of your main witnesses is appearing somewhere else, one of your experts is actually appearing in a different trial in a different jurisdiction, or counsel isn't available. So be ready at the options hearing with any notes of difficult dates. Again, it depends to some extent on jurisdiction. Some courts will fix dates afterwards by liaising with the sheriff clerk, but there are certainly some jurisdictions I've appeared in recently where they still expect to fix proof dates at the options hearing, and so you should be ready with a copy of any diaries that you need to have to hand in order to allow those dates to be fixed. Vulnerable witnesses and special measures. The court rules require you to advise the court at the options hearing whether it's likely that there'll be any child or vulnerable witnesses, and to consider what special measures might be required. I'm not going to talk about that in any detail, given that I think you could spend an hour just talking about vulnerable witnesses and special measures. But obviously there'll be some cases in which that is more likely to happen than others, but it's an issue which you need to consider, and to consider in terms of the rules at this juncture. One issue it might be able to assist the court on, although it's not covered specifically in the rules, is what the proposals are in terms of how evidence will actually be led at the proof. And increasingly, the courts look to have witness statements or affidavits lodged and used as evidence in chief for various witnesses. If that is the proposal, then I think it's helpful to advise the court at the time that proof is fixed, because that will obviously affect questions of duration as discussed above. Conversely, if it's specifically not the intention to use witness statements or affidavits, I think it's also helpful to explain that to the court in order to keep them advised as to what parties' intentions are. Expert witnesses, the court's rules don't require you to advise the court as to any specific experts which are likely to be led. But again, in terms of analysing your case, you should by this point have a clear idea of who is likely to be required, even if they've not been instructed. And I think it's helpful to set out to the court in your discussions about what a proof will look like, to say whether there are any expert witnesses in addition to the witnesses to fact which are likely to be led. So those are some matters that I think is helpful to be prepared to discuss if you think a proof is a likely outcome from your options hearing. What about a debate? When are you looking for a debate? Well, again, the court rules are relatively clear in terms of Ordinary Clause Rule 9.12.3c. A debate may be appointed if the court is satisfied that there is a preliminary matter of law which, if established following debate, would lead to a decree in favour of any party or to limitation of proof to any substantial degree. So either you've got a knockout point which kills the whole case, or you've got a point which knocks out a significant branch or arm of the case. The court's not going to be interested if you've got a sort of clever technical point, which might technically be correct, but doesn't really reduce the scope of any evidence that's going to be heard when the case is otherwise a relevant one. I think if you're looking to fix a debate, you should really be looking for something that either gets you decree de pleno or a decree of dismissal, or at least something which shortens the scope of a proof from a big proof to a significantly smaller proof in some way. In terms of examples from my practice recently about the sort of points that you might be looking to take to a debate, I've had a number recently. I've had one where the question was whether the defender who I was acting for is vicariously liable for the actions of the party who was sort of pledged to have been primarily negligent in terms of a personal injury case. Are we actually responsible for this party at all, was essentially the question for the court. And if the answer was no, then my client ought to be released from the action. Slightly similarly, I've had a case recently where the question is whether the defender is a public authority for the purposes of the Human Rights Act. And if it's not, then obviously none of the provisions in the Human Rights Act click into effect for the purposes of the pleading. I had a case relatively recently where the question was whether on the facts which were pled on record, whether a general meeting of an angling club had been competently convened. And that was important because the case was about the control of the angling club. And if the meeting which had elected the new committee hadn't been properly convened, then the action didn't really get off the ground. So it had the potential to knock the whole thing out. And similarly, perhaps one of the most common ones that a party might seek to take to debate, whether the action has been raised within the limitation period or whether it has prescribed or been subject to limitation. So those are just some examples of the sort of potential knockout points. It's very fact sensitive and it depends on the legal analysis of your case, but those are some ideas to give a flavour of the sort of things that might be considered at debate. Bear in mind, it is a debate on your preliminary pleas. They might be specific pleas in terms of time bar, jurisdiction, lis alibi pendens, etc. More commonly, it's perhaps a debate on the standard preliminary plea to relevancy and specification. If it is a question of relevancy, I think it's important to bear in mind exactly what we mean by an irrelevant case. And we have helpful dicta from the well-known Court of Session case, Jameson against Jameson, 1950, Scots Law Times 44, page, I don't think that can be the right citation actually, I think I've taken that down wrong. Jameson against Jameson at any rate, which says the true proposition is that an action will not be dismissed as irrelevant unless it must necessarily fail even if all the pursuer's averments are proved. The onus is on the defender who moves to have the action dismissed, and there is no onus on the pursuer to show that if he proves his averments, he is bound to succeed. So the question is essentially, even if everything the pursuer says in his pleadings are correct, so what? That doesn't give rise to a legal remedy. If that's the position you're in, then you're dealing with a question of relevancy in your case, and it might be proper to have the issue discussed at a debate rather than to fix an evidential hearing. I think it can still be useful to discuss questions of duration if seeking to fix a debate. Some debates take place on very discrete points. They can be done in an hour or so, and the court will only need to budget for a half day's diet in terms of the court timetable. Some debates, particularly in big complicated actions or in actions where perhaps matters haven't been pled particularly clearly, some debates might take 2 days. It's not unheard of for a debate to take longer than that. So you should be able to advise the court on how long you expect a debate to last, because that may well affect when you are likely to get debate dates fixed. So that's debates. We then have proof before answers, perhaps the hardest procedural mechanism to understand. Proof before answer is a proof in which the parties' preliminary pleas are reserved until the end of the hearing. So what you have is a hearing on the evidence in which parties seek to prove or disprove their various affirmance of fact, but there remains hanging over the case a question over whether some or all of the pursuers or defenders' pleadings are actually legally relevant. So you could still have a circumstance in which the facts on record are proved, but the court eventually says, no, you don't get a remedy from that. They tend to be fixed in circumstances where the application of the law is likely to be very heavily dependent upon the specific factual nexus of the case. So some cases can be readily understood from the pleadings, even though pleadings are set at a relatively high level, but there are some circumstances in which only really once the court has heard the evidence and has satisfied itself as to exactly what did or did not happen, can it actually consider how the law applies to the situation in question. There are various types of cases in which that might be appropriate. I'll give just two for the sake of brevity. Negligence cases, cases in which the court is being asked to consider what duty of care was incumbent upon a defender, readily require evidence to be considered so that it can be understood exactly what did happen in order to understand what the duty of care was and whether that duty of care was breached. So negligence cases tend to require a proof before answer. Cases involving, one other example, cases involving either facility and circumvention or undue influence, those sorts of things with adults with incapacity. Obviously, the case can be pled, and you can say somebody took advantage of someone's lack of capacity, etc. But it's likely to be to turn on specifically what happened on specific dates and what someone's capacity was, and that's always going to require the hearing of evidence. So those sorts of matters, I think it would be difficult, unless the case was plainly irrelevant on the pleadings. It would be difficult to determine them without hearing evidence on the matters, and so a proof before answer might be required. Preliminary proofs. Preliminary proof is just a proof, but which is focused on a discrete issue. Really, a preliminary proof is likely to be fixed when that discrete issue might be determinative of the case itself. So a proof at large will deal with all of the issues on record. Now that may, in a negligence action, that may include breach of duty, it may include any limitation issues, it will include causation and quantum. And so those can quite quickly build up to proofs that take weeks and weeks in order to determine the issue. But if there is an early specific issue which could deal with the case, then that should prevent a lengthy proof being fixed. Now, I say there it can focus on pleas in law, but the subject matter of a preliminary proof might also be an actual factual question. So a classic preliminary proof might focus on the question of prescription or limitation. Sometimes they can be dealt with at debate, but if there's a question of exactly what happened factually, then it may be evidence requires to be heard. But it's sensible often to deal with those questions prior to engaging with the full subject matter of the case, because determining whether an obligation is prescribed may only require a day or two of evidence compared to 2 or 3 weeks to hear the full case. So prescription and limitation is a sort of legal issue which might be apt for a preliminary proof. Sometimes the nature of someone's obligation to make reparations can be divided, so that one might have a preliminary proof on breach of duty and maybe causation, but hold over the question of actual quantum and how much someone has suffered in terms of salatium, loss of earnings, etc., onto a separate issue, because that will keep the scope of the proof shorter. Jurisdiction could be a matter of a preliminary proof, and there's no point hearing everything on the merits of the case if there is a genuine question about whether the court itself has jurisdiction. And perhaps the oddest example I can think of having recently is a preliminary proof on the identity of the defender in a case where it was a medical negligence case of all things, where it wasn't clear that the defender, and it wasn't admitted that the defender was in fact the individual who carried out the medical process on the pursuer at all. And so a proof could be fixed on that discrete issue before turning to the question of negligence at all. Simply, was the defender the person in the room or not? So those are some examples of issues that might come up in a preliminary proof. There are two other potential ways forward in an options hearing. It is possible that the court may continue the options hearing. It's important to bear in mind that that can only be done once in terms of the ordinary cause rules 9.12.5. The court may continue on one occasion the options hearing for a period not exceeding 28 days. So it's not the same as in the Court of Session, where, subject to a motion being made, the adjustment period could in theory continue forever. Really, what you can do in terms of the rules is seek 28 more days at most, which essentially allows for a further 14 days of adjustments. If the options hearing is continued, then the continued options hearing will then be treated as the options hearing for the purposes of the deadlines we've discussed before. So, as I say, you get a further period to adjust, etc. Technically, a motion to continue needs to be done on cause shown. So it's not simply enough for parties to say we want a continuation. There should be at least some reason for that. I think practically it's fair to say that if two parties come along to the court and say we'd like to continue the options hearing, it is unlikely that detailed submissions will need to be made as to the reasons for that. But it's important to bear in mind in terms of the rules, it ought to be done on cause shown, and there should be a reason. I've said that the deadlines essentially are fixed in terms of the continued options hearing thereafter. The question of whether to discharge the options hearing arises. There's a practice among some solicitors in some jurisdictions of seeking to discharge the options hearing rather than to continue the options hearing. And that's because, as I say, the options hearing can only, in terms of the rules, be continued once. And so the sort of clever wheeze is to say, well, technically you haven't had the options hearing because it was discharged rather than continued. For what it's worth, my view is that that's not really what the rules allow for. An options hearing can be discharged in terms of Rule 9.2a(1), but the rules are pretty clear that it says a discharge can be made at any time before the options hearing. And so my view would be, once the options hearing has called, the opportunity to discharge it has been missed. And if further options hearing is to be fixed, it will have to be a continued options hearing. My experience is that tends to be the position of more and more sheriffs these days, rather than allowing discharges to kind of get round the rule, as it were. And really, I would say that the better course of action, if you are in a situation in which even further time to adjust is required, is that would tend to be indicative of the fact that the case, rather than being continued, should be appointed to the additional procedure. When is the additional procedure appropriate? Again, the rules held in terms of ordinary cause rule 9.8.4. The additional procedure should be used on being satisfied that the difficulty or complexity of the cause makes it unsuitable for the Chapter 9 procedure. So the additional procedure in terms of Chapter 10, it's not tremendously different from the ordinary cause rules. Really, the big difference is that there is more flexibility in terms of adjustment. So further periods of adjustment can be sought by motion, as opposed to having the looming deadline of the options hearing and the inability to move that hearing. The additional procedure allows a motion to go in saying we need further time to adjust because we're dealing with further questions, carrying out further investigations, etc. That's the main benefit to it. At the end of the additional procedure, you will then have a procedural hearing. I don't intend to discuss that in any detail at all today, and the reason I don't intend to discuss it is because, for all intents and purposes, the procedural hearing forms the same fundamental role as the options hearing does under the ordinary cause rules. So come the closing of the record in the additional procedure, you then have a situation in which further procedure is discussed before the sheriff at the procedural hearing. And then you might well consider whether you need a proof, a preliminary proof, a proof before answer, or a debate. So those are the procedural options available to the court. And at most options hearings, you will be looking for the court to carry out one of those actions, either to fix some kind of evidential hearing, or to fix a debate, or for some kind of procedural decision, either to continue the options hearing or to appoint to the additional procedure. In terms of some practical tips before I finish on how to actually deal with the options hearing and preparing for it, the role of the options hearing fundamentally is to address the court and to discuss with them in an intelligent manner the further substantive procedure which ought to take place in the case. And it's a case management discussion, really. So the first thing to say is be prepared. You have to understand what the case is about. You have to be able to explain to the court what the issues in the case are, whether there are issues which are agreed, or what issues are the sharp issues which are in dispute between the parties. And as I say, there are some issues to do with witnesses that you need to address the court on, and there are others where it's certainly helpful to understand so that you can make intelligent submissions with regards to the length of a proof, the likely witnesses that are going to be heard, etc., etc. So understand your case. It is helpful for an options hearing to be carried out by the solicitor who is going to be conducting the proof, or certainly who has been involved in the conduct of the case so far for that reason. There's no requirement generally in terms of the rules to lodge anything similar to a statement of proposals for further procedure or a statement of issues or anything like that, which you might see in clinical negligence actions or commercial actions or judicial reviews. But it's not an unhelpful thing to carry out that exercise yourself anyway, and to note down quite clearly on your file, what are the issues which are in dispute between the parties? What will the court have to resolve at proof or debate? And what evidence is likely to be required, or what further investigations will be necessary in order to reach that point? Because that will then allow you to answer any questions by the court in terms of your proposals for further procedure. Similarly to that, I think understand the various tests for the various types of procedure that you want. So I've set out in the slides and in our discussions when a debate is appropriate, when a preliminary proof might be sensible, when the additional procedure ought to be invoked. The court may require to be satisfied that those tests have been met. And if you're not very clear on what those tests are, or when it's appropriate to fix that type of procedure, then you may find yourself in a difficult position and have difficulty with answering the questions of the court. So understand the various tests, and if you have any difficulties, go back to McPhail, and McPhail's got a very clear chapter on the issues arising in options hearings, etc. Be responsive / have a fallback position. It is a discussion with the court. It's a case management discussion. You may come with one proposal for further procedure, and the other party may come with a different proposal for further procedure. It may put you in a difficult position if you want to seek a debate, but the court decides that on the other party's motion it wants to seek a proof. You're in a difficult position if you then can't answer the court's questions with regards to how long a proof is likely to be, because you hadn't really thought about it, because you thought you'd definitely get a debate. So you have to understand, well, what if my primary motion isn't granted here? What can I say to the court about the position going forwards in terms of other substantive procedure? So have a fallback position. It is a discussion with the court. I'm reminded of a case recently in a sheriff court in which there were, I think, 4 parties who all turned up with a different proposal. One party wanted a debate, one wanted a proof before answer, one wanted to continue the options hearing, and one wanted to fix the additional procedure. And there was a sense that none of the parties had really spoken to each other about what their proposals were. And even during the options hearing, they weren't really able to discuss or respond to each other's submissions. They just each had their proposal and sort of said to the sheriff, well, can you tell us what's going to happen? I think it's helpful if you can look at another person's proposal, and you should be able to discuss this in advance of the options hearing with your opponent to consider, well, is their suggestion more appropriate than your suggestion? If not, do you have a sensible submission to make about why it's not more sensible? Are you going to be really difficult if they're seeking to continue the options hearing? Is there any point in you being really difficult and opposing that continuation and insisting on a debate? If their point is that they're going to fix their pleadings in the next 2 weeks, the court's not going to want to fix a debate on pleadings that could have been sorted out by way of further adjustment. So don't just go in with one stock position and an inability to discuss the various ways forward. I think you have to be able to discuss them with the court. Be succinct. The options hearing is likely to be heard on a busy ordinary roll. There might be 20, 30 other cases being heard. The sheriff should have had an opportunity to have a quick flick through the closed record and perhaps to read any Rule 22 notes which have been lodged. They're not going to have a detailed understanding of the case, but neither are they going to want you to give them a detailed understanding of the case by taking 15 minutes to explain the contentious, difficult background of the case and all of the main characters and everything that's being sought. You should assume some level of knowledge on the sheriff. You should perhaps check with the sheriff at the beginning of your submissions that they are aware of the issues arising in the case, but otherwise you should be able to say quite succinctly, this is a case about payment under a contract. The sum sued for is X. The amount has been outstanding for significant time. The defender's position is that the sum isn't payable under the contract because the work was done negligently. On the basis of the pleadings, I don't see that there's a case for negligence, and that's why I'm seeking a debate. That kind of thing. It should be a short, sharp, clear explanation of what the position is and what the issues are. The court won't thank you for a long discursive explanation of the issues standing the busyness of the court. The last thing to consider is, are there any ancillary motions that the court might need to consider at the options hearing? It may be that adjustments have been intimated late and there should be a motion for those adjustments to be received late. It may be that the closed record has been lodged late. I should say the options hearing record has been lodged late and it needs to be received late. There are other issues that it might be helpful to deal with at the options hearing because it is an opportunity in which ordinarily the case will call anyway. So it may be if there's anything you require to recover by way of a specification of documents, it would be sensible to have that motion put before the court in time for it to be heard along with the options hearing. Similarly, the taxation rules obviously require sanction for experts or sanction for counsel to be sought either prior to the expert or counsel being instructed or for there to be cause shown as to why it's done after. But if you can line that up with the options hearing, if your intention is to fix a proof and to have counsel appear at the proof, it's entirely sensible to seek at that options hearing for sanction for junior or senior counsel to be granted in order to allow that to happen. So there may be other ancillary motions as well. I think in family actions in particular, I think there are often ancillary motions to do with interim contact, etc. So those are really some of the top tips. Be prepared, understand the various tests, be responsive, have a fallback position, have a discussion with the court. Be succinct. If your options hearing is taken anywhere near as long as this talk has taken, then the sheriff, I suspect, will be furious with you. I did have one options hearing once that I watched with two of my colleagues that did take about an hour and a half, and I don't think the court was very pleased about it. I certainly wasn't pleased sitting there waiting to deal with my motion to amend in a different case, and consider whether there's any other motions or issues which ought to be raised before the court. I hope that's been helpful in terms of dealing with the various issues that might arise before and during the options hearing. I think there's still maybe 10 minutes to have a bit of a discussion with any questions arising. But otherwise, thank you very much for your time.
Thank you so much, David. That was so thorough and so informative. And I feel like I can speak for everyone when I say we're going to take a lot away from your presentation. So thank you. I can see some questions coming through in the chat box. I've actually already had one sent to me directly as well. So to start us off, first question, since The options hearing can only be continued once. What options are available to you if you still aren't in a position to agree further procedure when the continued hearing takes place?
So, I mean, I think the classic answer to that is that it's probably a case for the additional procedure then. So the additional procedure should provide you with more flexibility in terms of adjustments. And I don't think it's an unfair submission to make to the court that this is now the continued options hearing. This is a complicated case, my lord. I think the ordinary cause rules are designed to be used as a template for most cases. A lot of cases in the sheriff court are reasonably simple or deal with one or two pretty clear-cut issues. If a case is becoming complicated, if you need more time, I think it's appropriate to seek to have it appointed to the additional procedure. And quite often that will be a joint motion of both parties if you're simply at a point where the record can't yet be closed. The other option, I suppose, is you could seek to assist the case prior to the options hearing. Some courts might be suspicious of assisting the cause and having it sort of drift and the court losing any control over it. But I think that's an appropriate and competent motion to make as well in certain circumstances.
Absolutely. Thank you, David. The next question is, could I ask, is there an example of when a preliminary proof would be assigned to deal with a plea rather than a debate being assigned?
So, I mean, I think sometimes, as I say, prescription and limitation issues, sometimes they're pretty clear on the face of the pleadings that something has or hasn't prescribed, and the only question is how the law works. But sometimes, certainly I've had preliminary proofs fixed in limitation cases through Section 19A and equitable extensions of the time bar. You can put what you can put in the pleadings, but sometimes the court might say, well, we actually need to hear evidence with regards to whether it is or isn't fair to continue the time bar here and to fully understand what the pursuers have done. So preliminary plea on time bar limitation or prescription might be done. I think there's a relatively recent one. I don't think the decision's out yet, actually, but there's the Kenyan tea pickers case in the Court of Session where it's all about jurisdiction. But again, really complicated questions about Kenyan law, which is foreign law, so it's a matter of evidence. So again, preliminary proof was fixed there rather than a debate on jurisdiction. So it just really depends on whether it's likely that the court will be assisted by actually hearing evidence on the matter.
Yeah, so quite bespoke to the matter at hand then, I suppose. Thank you, David. And then our final question in the chat box: do you have any advice for preparing fallback positions?
So, I mean, again, I suppose what you just said there about it being quite bespoke is still the issue, that it's difficult to say. I mean, what I'll say is, I have one colleague at the bar who I've turned up in an opposed motion with once, who said, "This is, my lord, this is my primary position. And if you don't accept that, I have 9 different fallback positions, and these are them." I don't think that's a helpful thing to do. I think that makes you look mad. But I think you know, your classic one is you're seeking a debate because you think you've got a knockout point, and the other side want to fix the proof before answer because they say, well, even if the case is irrelevant, you want to hear some evidence on it first. I think if you're looking to fix a debate in those circumstances, you shouldn't go into that hearing without having an idea of what a proof before answer would look like if that's fixed instead. So you should be able to say to the court, okay, I think a debate should be fixed for all these reasons. I think that can knock the whole case out. If you're not with me, they say they can have a proof before answer in 2 days. I think that's wrong. I think it's going to take 16 days. That's one of the reasons I want a debate, because I've got all of these witnesses that are going to have to come along and speak to all of these difficult issues, when actually the only issue that matters is the fact that they've not pled a relevant case on X. So I think that's probably the classic one. Equally, I think you have to be prepared if someone's going to fix a continued options hearing or additional procedure. I think you have to be flexible and think about whether it's worth having a fight about it. Fundamentally, the court will want the pleadings to be put in good order before the record closes. So I don't think you'll get very far if you insist on fixing a debate on some clever point if someone's offering to fix that clever point. So think about the issues arising in the case and what the court's likely to do with it, as well as what you want the court to do with it, I suppose, is the only real advice.
Thank you very much, David. We've had no other questions coming through to me directly or in the chat box, so it's just left to me to say on behalf of SYLE, thank you so much to yourself, David, for delivering today's presentation, and thanks to our audience members for engaging with the session. We have a number of further Precognition to Proof sessions coming up over the coming weeks and into the summer, and all of those are now advertised on our Eventbrite. So if you enjoyed today and want to join us again, you can sign up on there. So I'll end the meeting now, and have a lovely day. Thank you.
Thanks very much.